5 seconds. Start. The next argument is the argument based on the difference between the words within as found in CRZ 1 as contrasted with the word in CRZ 2. We are called upon to employ a purposeful interpretation bearing in mind also the distinction in the words used. Much reliance has been placed on the judgment. The said matter arose under the coastal regulation notification issued in the year 1991. The MOEF granted permission to the respondent therein for construction for setting up of a marine terminal facility near the seashore for receiving and transferring VCM, which was one of the raw materials for manufacturing PVC. Under the terms of the 1991 notification, certain activities were prohibited under paragraph 2. They included manufacturing or handling or storage or disposal of hazardous substances as provided therein, except transfer of hazardous substances from ships to ports, terminals and refineries and vice versa. In the port areas, the question failed for consideration as to the interpretation to be placed on the words in the port areas. We feel advised to refer to the following portions of the judgment reported in the law reporter. It was contended by the senior counsel for the appellant petitioner that transfer of VCM in CRZ area is completely prohibited and VCM cannot be carried through the CRZ except in the port area. Their argument is that VCM can be brought onshore by pipeline to the port area but not in the CRZ area. The arguments of learned senior counsel have put in issue the scope of expression except transfer of hazardous substances from ships to ports, terminals and refineries and vice versa in the port areas, which was added in para 2 under bracket 2 on 9/7/1997. We are called upon to ascertain to the true meaning and intention of the executive in bringing this exception. In the original 1991 notification, there was no exception clause. It appears to have been added for the purpose of enabling transfer of hazardous substances from ships to ports, ships to terminals and ships to refineries and vice versa. In such transfer of hazardous substances confined to terminals and refineries located in the port areas, the answer in the affirmative may make the said provision unworkable and would also result in absurdity in as much as the hazardous substance would be brought into the port. It is well settled that if exception has been added to remedy the mischief or defect, it should be so constituted that it remedies the mischief and not in a manner which frustrates the very purpose. Purposive construction has often been employed to avoid a lacuna and to suppress the mischief and advance the remedy. It is again a settled rule that if the language used is capable of bearing more than one construction and if construction is employed that results in absurdity or anomaly. Such construction has to be rejected and preference should be given to such a construction that brings it into harmony with its purpose and avoids absurdity or anomaly, as it may always be presumed that while employing a particular language in the provision, absurdity or anomaly was never intended, notwithstanding imperfection of expression, and that exception clause is not happily worded. We are of the view that by applying purposive construction, the expression in the port areas should be read as in or through the port areas. The exception in para 2 under bracket 2 then would achieve its objective and read except transfer of hazardous substances from ships to ports, ships to terminals, and ships to refineries, and vice versa, in or through the port areas. This construction will be harmonious with para 3 under bracket 2 under bracket 2, which permits the activity of laying pipelines in the CRZ area. On the one hand, the learned counsel for the appellants would place considerable reliance on the view taken by this court. Per contra, learned senior counsel would submit that the aforesaid decision turned on the facts obtaining therein, and in particular the expression in the port areas, whereas the language used in paragraph 8 under bracket 2 under bracket 4 and also the context should persuade this court to place an interpretation advancing the object of a notification, such as the 2011 notification, a pursual of paragraph 36 of the judgment would show that the contention of the appellant therein was that the transfer of the raw material in the CRZ area was completely prohibited and it could not be carried through the zone except in the port area. This court understood the terms of the notification to be that it permitted transfer of the hazardous substances from the ships to the ports, ships to terminals, and finally ships to the refineries. The vice versa was also found to be within the contemplation of the notification as permitted activities. The court posed the question whether the transfer was to be confined to refineries and terminals which were located in the port area of the terminal there. Stop.